Apologies for that, and hopefully we can reconvene. Are we online?
About 2 seconds now. Yep.
Okay. Where are the lizards likely to be?
Yep, good question. So Southland green skink prefer tussock land and I guess Dracophyllum, fernland, low, flaxlands. The Corero gecko, which were there in 2001, their habitat is rocky outcrops, rocks with crevices that they can hide in. And then the cryptic skink, I did look it up actually, I just can't think of it off the top of my hand. It's more like tussock land, open grassland species. So they may be present in the, I guess what I was trying to get to earlier on was that Carrie Knox has only looked at one location, and it was in the modified pasture land, I think it was, or I can't remember the actual term, of the, one moment, right. He looked in improved tussock land, which was 50% tussock, just at one location. And so we do have records at DOC of Southland green skink and Corero gecko and cryptic skink elsewhere on that property. And so that was kind of my biggest concern, was that he's only looked at one site. And so they could still be there, but the survey hasn't been thorough enough to actually determine whether they're there or not.
Okay, so reference in the rules as to the rock outcrops to stay away from those.
Yeah.
So okay, if there's gecko, no, the geckos in the rocky areas for the other lizards, if they're there, many of those areas have been grazed, and if they are still there, then they've managed to survive through the regime that's applying to the land. And if they're still there, what can be done to protect them?
Yeah, so all Indigenous lizards are protected under the Wildlife Act, so any activity technically that's going to disturb, injure or kill lizards needs a wildlife permit.
But they've been doing it for 100 years, so
yeah.
In terms of what they have been doing in the past, does that trigger the need for a retrospective consent of some form?
Well, I can't comment on that, but I'm just looking forward. Ideally, they would undertake a lizard survey of the area that they're going to work on, and understand whether the values are there, whether the lizards are there, and are they going to be impacted.
So the key is where they're wanting to change what they're doing now, then under the Wildlife Act they need a approval of some sort.
Well, that's right.
But if they're just continue to manage it the way it is, then they don't.
I can't definitely comment on that, but any new earth disturbance, veg clearance, including exotic grass clearance for fencing or tracking, yes, technically that should have a wildlife permit. Well, you know, first a lizard survey, work out, are there any lizards there? What are the impacts or the effects?
Yeah, so this is where the difficulty arises. If you don't see them, how do you know they're there? And is it reasonable to expect every farmer in the Gore district, if they're wanting to do some work, to go out and do a lizard study?
I can't answer whether it's reasonable. It's just you are meant to be doing that. That's the law, so they are protected. Yeah, I mean, what can I say?
Well, I have lizards on my property, so I suspect they're on the farm next door as well.
Sure.
Which is beautiful grassland, with the like. So from a practical point of view, I guess your legal advisor is about to give me some advice.
So in relation to the Wildlife Act, which is 1953, there's obviously a particular regime in relation to taking or disturbing. But in relation to, and you're not so concerned with that, what you're concerned with is whether it is significant habitat for that indigenous fauna. So not every single incident of a lizard where you might find where it's been. You need an ecological assessment or some ecological understanding as to whether it's significant. That's as far as I can take it, I think.
Yeah, and tomorrow with Matt Heal, we will be exploring the regime that's been promoted where there is criteria in the plan in terms of the appendix at the back and the MPIS, Indigenous vegetation, versus what we're about to talk to with Elizabeth over the notional mapping that has been done. So I'll leave the rest of it to follow through shortly.
So it's establishing where there is significant habitat, not just in relation to the Hokonui Hills area, or is the reason that you focused on the Hokonui Hills area because of prior survey that has, and there's not elsewhere in the district where that kind of information has thrown up existence?
No, that's right. So the reason we're focusing in on the Hokonui Hills precinct is because there were records of Southland green skink there, and obviously they're nationally critical, the highest threat ranking, and 2 other species of lizards there from previous surveys. So that's the reason I'm focusing in on that area. You're right, you need to identify what lizard habitat is there and then what lizards are there. And qualified experienced herpetologists would do that for a farmer. Yeah.
And in terms of my question, outside the Hokonui Hills, other surveys haven't thrown up other areas in the district with a similar issue?
No, not that I've seen. Not on our doc records anyway, no. Thank you.
And then the only other thing, which is a good segue to Ms. Williams, is in terms of our conversation at the start around protect and maintain and what the MPS does, thinking about the places that where you've got Indigenous biodiversity outside the significant areas, that's where we end up with what you do if there are significant adverse effects and what you do if there are other adverse effects, and that's where that gradation comes in. And so that's just a nice wee segue to Ms. Williams, because there are really 3 things going on, aren't there? There's the significant areas / habitats. There's the significant species because of their threat classifications and what we have to do for them. And then there's there's 3 tiers really. There's other Indigenous biodiversity with significant effects on it. And then there's other Indigenous biodiversity with other kind of effects that are less significant. And all those 3 tiers of management are anticipated by the MPS. I'm getting a nod.
Hi, kia ora. My name's Elizabeth. You can call me Liz. I'll just briefly go over some of my key summary points. So the DG submission sought a number of amendments to the provisions in the Eco Chapter. Overall, my evidence generally supports the Section 42A Officer's report recommendation in relation to these submission points. I accept the approach of the Section 42A report officer, which is to include reference to SEVAs and IVAs and to include an indicative map outside of the plan to guide plan users about when the eco provisions apply. I guess the outstanding matters which we've discussed today is with the proposed Eco R2 and the Hokonui Hills provisions and significance assessment. So I won't go into too much detail about that, but certainly welcome to answer any questions. I think I've just summarised to say, even with the supplementary evidence, I still retain my original recommendation that Eco R1 is relied upon for this area, and that where resource consent for Indigenous vegetation clearance is required, there could be a process to develop a council authorised biodiversity management plan. However, if the panel are minded to retain Eco R2, then I think amendments are required to clearly map those areas that identified as significance or have been identified against the significance criteria within the Appendix 7 map, and to ensure that the permitted Indigenous vegetation clearance rules that are associated with that map are tailored to reflect these areas of significance to align with the higher order documents. Did you have any questions?
Cliff? No? Maria? No, sorry, Dennis? No. Maria, if you go first, I just want to check something.
Okay, were you here when I was having the conversation with Ms Perkins about council approved biodiversity management plan?
Yeah.
And so if that is the pathway, then would you agree that you need to know what the management plan, what principles might be going on there, what outcomes are sought, what's the process for the development and approval of such a plan? That there are a number of elements that we would need to make a success of that. It would be really great to have your comment on that.
Yes, I agree. There should be a sort of a set process to develop these plans. In my original evidence, I attached the Selwyn District Council example where it had an appendix, and it sort of goes through what should be included in those plans, what gets looked at as part of that management plan. I think that's a good process to use. It's clear and it provides some flexibility in terms of identifying where areas are protected and where existing continuing rural activities can occur. Yeah.
Can you see there's some logic in what Ms Perkins is saying in terms of they, at the moment, understanding that DOC do not support the rule framework as put across, but just purely from a planning perspective, that what they've identified is that permitted activity rule, which would trigger a consenting pathway outside of its bounds, but that gives them sufficient flexibility to do everything that they would want to do on a regular basis. So they're kind of like, we don't really need a management plan because we've got the flexibility already in the rule framework.
Yes, I kind of think that the proposed Eco R2 may be more restrictive in the sense that if they don't have their plans of where the proposed new fencing, etc. is going to go, they'll still have to apply for a resource consent and go through that process if it exceeds those area amounts. So I think doing it through sort of a biodiversity management plan, you can kind of look at all these different aspects and what's being proposed for that site and sort of try and identify significance and areas that possibly, you know, you can allow continuing existing activities or propose new activities within those areas. So it gives a more holistic approach rather than through proposed rules of a district plan.
How is it that biodiversity management plan can better give effect to the MPS and the RPS than the rural framework. Is that a thing? Or is it really that either mechanism could do it, but there might be reasons why you'd lean towards a management plan?
I think either way you could give effect to the MPS through the provisions in the district plan or through the biodiversity management plan. You would be looking at what the adverse effects of those activities that they're proposing would be, and looking at that against the significance to avoid effects, and then for the maintenance of Indigenous biodiversity. I think the benefit of doing it through a resource consent is that the biodiversity management plan would have legal weight because it would be part of a consent conditions. It would get monitored. I'm not sure if you did a conservation biodiversity management plan outside of the plan process, how those things would be monitored.
So it's using the management plan as part of a resource consenting process, which you quite often see with infrastructure projects, that kind of thing, as opposed to the management plan being associated with the permitted activity rule. Mm-hmm.
So I guess it comes back to how do you know when a management plan is needed?
And so if you relied on Eco R1 and if there was a proposed Indigenous vegetation clearance that was exceeded what's allowed through those permitted activity rules, I would say that would be the time that you required something like that.
So
It could be a tool to assess
Right.
the effects of
And
that
so
activity.
when a landowner comes into the council saying, do I need a consent, looking at the plan, how do you expect that process to go?
So in terms of Eco R1,
Yes.
so the indicative SEVA and IVA maps, which sit outside of the plan, give you an indication of which areas may be more significant than others, and the Indigenous biodiversity clearance rule is a broad brush approach to apply to the whole district. So somebody who was coming in and proposing activity, they would need to check if they fell within those list of permitted activities, and if they didn't, then they would require resource consent. And they would know, probably they would have an idea of where it fell within the significance or not through those provisions in the restricted discretionary and discretionary provisions, because it falls to non-complying if it's...
So I guess for both planning and legal, are you satisfied that in fact that is a valid process to follow, given that it sits outside of the plan and you're using it to determine a rule?
It sits outside the plan, but it's an indication. So once you identify you need a resource consent, the resource consent process is a mechanism to assess or ground truth those indicative planning maps. So that's the stage that you would undertake an ecological assessment and determine whether you fall into a significant Indigenous vegetation area.
So you're required to do an assessment to see if you need a consent?
No, no. It would be, you would require consent if you fell outside of Eco R1 rules. That doesn't need, it doesn't say that you have to.
But our Rule 1 only applies to areas of significance. So how do you, without doing an assessment, you won't know whether you comply or not?
So Eco R1 is just for general Indigenous vegetation clearance, and then if you don't comply with that list of permitted activities, so that's any clearance in Indigenous vegetation, then it trips over to the Eco R1-2 and Eco R1-3. So if you fall outside of Eco R1-2, which I think just applies to certain activities that breach the clearance rules, then you fall into a discretionary activity which has some criteria which you need to meet if you're going to stay within the discretionary activity status. So that's the time that you would do that assessment to determine whether you met that criteria. I think I have that right.
Well, how does scale come into it? At what point are you doing Indigenous vegetation clearance?
So it would
One
be,
tree?
So it's any of these. So if you fell outside of these permitted activity
Yeah, but
rules-
if I'm taking out one tree, am I caught by the rule? If I'm not doing any of those things?
I don't think so. Not if you're just removing one tree. It would be whatever's defined in the clearance of Indigenous vegetation definition. So if that triggered, whatever you were doing, if that definition triggered that activity, then
You'll have
That would
it at
apply.
your fingertip, Matt. What's the definition? Or what's the answer?
The definition's in the plan. If it's Indigenous vegetation of any type and you're clearing it, you need a consent.
Yeah, so for 1, 2, 3 trees,
Yep.
regardless of what the extent of impact is on the ecological values.
Apart from the 50 square metre control. Or if you're doing it for an existing fence or what have you.
So that rule, the 50 square metres in 5 years, is there to allow for the one-off removal of a tree without needing a consent. So it's one of those minor activities, minor effects activities that have been given permitted status.
So the SEVA and so a significant Indigenous vegetation area and an Indigenous vegetation area are both subsets of Indigenous vegetation. So that just determines whether you are a discretionary activity, if you're in a EVA, and a non-complying activity if you're in a SEVA, if
Okay,
you're
but
not meeting the permitted
But
standards.
you've got to do a study to work out which one you're in.
No, not to
No.
work out which one you're in. You would do a study to understand the effects of your proposal. So that's the point at which the landowner incurs the cost of an ecological assessment, and an expert ecologist essentially ground truths those maps, which are very high level, and determines, in actual fact, we've assessed the ecological values on the site in a ground truthing exercise, and we've assessed the proposal, and this is the effects we think arise from that activity, and these are the recommended remediation or mitigation or compensation steps that may be needed in order to approve that consent. So that's what the ecological assessment would inform, and that's,
where the effects management hierarchy would kick in.
yes.
Right. So we're getting to the crux of things. So Eco R1 falls into the category of that 3.162 of the MPSIB, i.e. its other adverse effects that may adversely affect Indigenous biodiversity outside NSNA. So it's capturing that tier of less than significant effects, obviously, because it's a PA, so, you know, just the standards for a permitted activity, for vegetation that is not in itself significant. Yeah. And so this is where the issue for DOC comes in terms of the settings in the permitted activity if it inadvertently picks up either significant habitat or significant species. But otherwise, so if the permitted activity doesn't pick up significant habitats or significant species, not an issue, you could then move into the consenting framework where all the other matters come into play in terms of significance in the effects management hierarchy. So the core thing that I'm trying to understand is, how do we know that Eco R1 doesn't have the same problems as Eco R2 in terms of capturing something significant? Why is DOC more comfortable with Eco R1 than Eco R2 in that respect?
If you look at the proposed Eco R1, there's provisions in there that it will not adversely affect threatened or at-risk species. The improved pasture has not become an SNA. Those types of things, which are the clauses that capture those things.
I might be able to help too here, and that the main change between 1 and 2 is that apart from the 50 square metre clearance limit, 2 provides for larger clearance limits in A, B, C and D, which 1 doesn't do. That's the main distinction.
It goes to the table, well, you know, we had a table in Ms Perkins' evidence that was doing a comparison between the two. Hence the issue that Doc are raising, the ABCD. Right. Crystal clear.
I'd be interested in your view as well, and I'm looking on page 13 on the right-hand side that says it's discretionary activity where number 2, the vegetation clearance, and earlier talk is land disturbance comes out. Vegetation clearance does not affect a threatened or at-risk declining species as confirmed by a council-endorsed ecologist. So an independent person is then determining whether it complies with that and therefore whether it's a discretionary or non-complying activity. And I see even if there's a positive effect, it's caught by that. The word adversely affect needs to be added to it. But from a planning point of view, what happens if there's a contrary view in terms of another ecologist saying the council-endorsed ecologist has got it wrong?
Yeah, it would be through the resource consent process. So I guess you could request further information, get it peer reviewed, an ecologist report peer reviewed, could go to a hearing to discuss the matters.
Yeah. So the point is, it's not until you're actually in a hearing that you can work out what the status is of the activity, and you've got evidence that actually agrees with the endorsed ecologist view, or if it doesn't, then it's up to the hearing committee to determine which it is.
Only if it was contested, though, that would be.
Well, yeah. So I'm interested in the legal view on whether that's actually valid.
Sorry, I'm not sure what the question
So-
there is, sorry.
So is number 2 there a legally appropriate discretion to have in a rule?
In terms of the wording as confirmed by the council endorsed ecologist?
Yes.
I can't think of any reason why it wouldn't be. I suppose your concern is it seems to be a definitive rather than opening the door for contestation at the consent hearing. Is that
Yes.
where you're going?
Yes.
I'd have to give some thought to that. I don't know whether Miss Chadwick wants to give some thought to that as well.
I'll be asking her in the morning.
Yeah.
I'll be asking Ms Chadwick in the morning exactly the same question.
Yeah.
So in some ways is the biodiversity management plan really a bit of a distraction in the sense that if you've entered a consenting pathway, which is the only time that you're imagining this would be a useful tool, isn't it something that any applicant could offer up as part of their consent regime? Then the mechanics of how it's, what it contains and how it's monitored and all that stuff just gets dealt with through the consenting process. So it, in terms of that, I mean, that's really it, isn't it? We probably don't need to spend much more time on it in that way, because that will be up to that consenting process and any decision makers in that consenting process, rather than anything we need to guide ourselves.
And the analogy to Rule 2 is, though it's been treated as though there was a consenting process, and if there was a consent issued, what is in Rule 2 would have been the conditions that apply to that consent. And I understand fully that your argument in the consent hearing would be exactly the same as what you're saying here today, and that all the relevant factors haven't been looked at.
Yes. Yeah, that's right.
Okay, Maria, anything else?
Can I just clarify something? Because currently, Rule 1 trips to full discretionary if you're outside of SEVA, if you're in an EVA, basically. Whereas what DOC were agreeing they could live with, I think, was the Selwyn District Council approach, which trips to restricted discretionary. So there may be an incentive, quite a small one, I believe, to go down an RD path if you're providing a council-approved biodiversity management plan. And if you're not,
And now I'm thinking that you really don't, even if you went into the RD space, surely your matter of discretion could simply say a biodiversity management plan is something that you can consider as your matters of discretion. You don't even need a council-approved thing in there. You basically can just say you've gone off and had a go at a biodiversity management plan, rock up with your best effort and we'll have a look as part of our matters of discretion.
So can you just hold off for a moment while I write all that down, please? So I think that's an important distinction.
Because the authorisation then comes through the consent process. Yeah.
When I was originally reading council authorised biodiversity management plan, I was actually imagining more of these, and I know it's nobody's favourite thing, but farm management plans that come through permitted activity rules. That's something that I'm familiar with from a regional council background. It's not been uncommon over time. Its effectiveness could be another question, but you know, then you've got the other kind of examples where it's a project going through a resource consent process, and then you know, that's just an available offer as part of an application suite. I would have, yeah.
Does DOC have any concerns over the extent of the detail of Appendix 7?
Yes. I think because it refers to areas A, B, C and D, but it's not clear whether those are SEVAs or IVAs or what they are against the significance criteria. So we've discussed that today, and I think that should be clarified in the appendix.
And on our copies as well, the colour differentiation isn't
difficult.
good.
Yes.
So when we were sitting reading it beforehand, we actually thought it had the same colours on the two different properties and different parts of it.
That's right.
But the explanation we've had this morning is that the letters apply to the different properties.
Yeah.
And we posed the questions in terms of should the heading actually be SEVA and EVA, A and B, yeah, for clarity.
Yeah. And I think if there are any areas that are set aside that are exempt from those rules, the Eco R2 rules, then they should be mapped out on the Appendix 7 map.
So what would be the areas exempt?
So there was a suggestion from one of the ecological evidence, I think, that suggested that that area that's part of the land management agreement is exempt from the permitted activity rules in Eco R2. So I think if that was the case, it needs to be clearly mapped out and the rules need to reflect that.
So the issues raised about the enduring agreement, you see that as an appropriate tool to achieve that by exempting it, by setting it aside from the rules in R2.
I think it's because it's been identified as a significant area, and so yeah, it shouldn't follow the same sort of exemptions that some of the other activities have. under the permitted activity rules. Apart from existing activities.
And our challenge there is the one that Commissioner Havell raised earlier on, which is with the moratorium on mapping SNAs, and where that leaves us in terms of understanding that we do have a significant area.
I missed Ms Chadwick's submissions on that, on the Amendment Act, the 2024 Amendment Act, but it's really important to remember that it removes the obligation to deal with that in a mandatory way. You've still got to address Section 6C, and if this council chooses to deal with it in a particular way, then that's valid. The 2024 Amendment Act removed it as a mandatory duty on you.
So you're very clearly telling us there is nothing to prevent us mapping our location as holding significant habitat or significant species.
Yes, and that, of course, before we had the NPSIB, brought in August 2023, was a common planning method for protecting those areas. It's just codified in the NPSIB, and the government put a halt to the mandatory requirement for all councils to use that, but you can still choose to do it if you wish. And the explanatory note, I'm not sure whether I think I include it in one of the footnotes in my original submissions, makes it clear. The explanatory note to the bill. Footnote 24.
Okay, anything else from the panel? You're thinking, Maria?
I might put it another way and just check with the DOC team if there is anything remaining that you would like to bring to our attention, because we've got you here for this moment, notwithstanding that something further may occur to assist us.
Well, I'd like to go back to the planner. We've got Section 6 matters in terms of natural features and landscape that includes a big chunk of the Hokanuis. And we've got this chapter. Should one of them have priority?
I don't think one or the other should have priority. Are you asking in terms of where the provision should sit within those chapters, or?
If we have a choice in terms of the what we have in the plan, and there's conflict between the two provisions, i.e. the removal of vegetation or so there may be a minor ecological effect in terms of removing vegetation, but a significant landscape effect, or vice versa. Is there one that should have priority over the other? Because what the courts have told us is that where there's conflict between Section 6 matters, you can give weight to one ahead of the other, if I understand it correctly.
Well, Section 6C is unqualified, as Mr Heal has explained to you. So if you were just looking at Section 6 in isolation, forget about the planning framework, you were just looking at Section 6 in isolation, there could be an argument made that Section 6 is a weightier, it's not what the law says, but I suppose theoretically, in your context, you could consider Section 6C to be weightier because it's got no qualification to it for appropriate uses. But you can't really look at Section 6 in isolation. You have to consider what the planning framework says to you, and we know that we have the MPSIB telling us to behave in a particular way, that you have to give effect to that, is there an equivalent NPS telling you to favour landscapes? No. So the question is perhaps slightly asked the wrong way. It's really looking at what the planning framework is telling you to give effect to. So we're going to say the MPSIB is going to take priority because of the planning framework. But I may be wrong about that because I haven't done a full evaluation of all of the regional policy statement objectives and policies in relation to natural character and landscapes.
Yeah, well, we understand miracles take a bit longer to respond to than the impossible, but so in that context, looking at the way that the links apply between the different chapters and between the assessment matters, which is what it boils down to, and back to the doc submission that said in landscape have regard to the ecological values, and I don't think I've seen much on the ecological side of things where submitters have said have regard to the landscape values. So should we be putting cross-references back to the landscape values in the assessment matter?
I probably have to have a bit more of a think about it because I haven't looked at the natural character chapter for a while. I've just been focusing my efforts on the eco chapter for now. But I think our submission was to do with acknowledging that ecological values are a part of forming the natural character. Whereas when you look at the eco chapter, we're looking at the adverse effects of the biodiversity values and what adverse effects those activities will have on the biodiversity values. So if there's crossover provisions, I think through a resource consent process, you would weigh up both chapters and what the policy objectives say for both and assess it on its merits.
Okay, so that's helpful. Thank you.
I realised I finally got round to the question that was bubbling away in my brain, was that if we are allowed to map an area that has significant habitat and has significant species in it, but it is not the significant natural area directed by the MPS, what then happens to the specified infrastructure carve-out? Because that was one of the arguments that you were bringing forward around that some of what's proposed in the Stony Creek provisions falls outside the specified infrastructure, and I'm like, does that matter if it's not a significant natural area mandated under directed by the MPS, but it's a different mapping that's occurred to ensure that we can manage significant habitat and significant species? Are we then bound by the specified infrastructure, and are we then instead looking more at the effects of the activities we're talking about?
And that's something that's been bubbling away in my mind as well, because of course the 2024 Amendment Act only disapplied certain very discrete provisions of the MPSIB. So what do you do with all of the rest of them? To be honest, it's something I'd have to reflect on and give you clear thoughts. But I think my approach to it was that you'd have to have, in order to recognise and provide for the protection of significant natural areas, which is your statutory mandate under Section 6C, even if we put aside the clear exceptions that are in the MPSIB and we're not sort of complying directly with that or implementing that directly, what it is telling us is that there would have to be narrow and well-justified exceptions for clearing at SNA. That's SEVA, that's significant vegetation under Section 6C. And before the NPSIB came into being, planning practice had already established the idea of an effects management hierarchy because that links back to Section 5, the Section 5 ideas of avoiding, remedying and mitigating. So I still think that is, even if we have to put the NPSIB to one side, best practice brings in that idea of the effects management hierarchy, which was what I was referring to when I was speaking. Yeah.
Okay. So if we go back to the NPSIB in that the section that's dealing with things that are outside an SNA, with the SNA being defined by the MPS, is that guiding us in our situation?
Yes, I see where you're coming from with that. But for the problem with just relying, it could guide you as a sort of minimum, as a sort of ecological bottom line, you know. But remember, that was the wider context of that was the clear differentiation between how you manage significant areas and how you manage everything else, and that was the everything else. And it was written on the basis that we can write it in this way because we are protecting significance in another way.
Is this a reason why, even though I asked you the question earlier about the MPS being newer than the RPS, that there will be situations when we are looking at these two instruments where it might be wise to lean back on the RPS?
Yes, thank you for that. Absolutely. I mean, if in doubt, if you are, or if you decide that you can't apply those NPSIB rules, yes, you still have to give effect to the regional policy statement. Yeah.
Okay, so if we think then about that specified infrastructure question, and if the MPS can't help us much on that because it's relying on an SNA having been mapped and there's only a couple of them in the district. So then we lean back on the RPS and what the RPS says about infrastructure happening inside these significant spaces. Is that where we should be drawing our guidance around really the two main activities that Stony Creek are routinely putting in front of us in terms of each of the chapters that they're turning up to talk to us? The main thing, aside from the day-to-day farming activities, is to know, well, A, that they can maintain the existing stuff, and I think that's not causing us as much trouble. The thing that's causing us trouble is, in previous hearings, there's been talk around, over the life of the plan, potentially another 8 kilometres max of new fencing and any associated tracks that would go along with doing that. And that's related to the evidence that they've brought to us repeatedly and again today around needing to take the paddock sizes down from the 60 to 80 hectares to 20 to 30 hectares of paddock, and that will necessitate some new fencing. So really what they're bringing to us is these two things just regularly: farm tracks and fences, existing and a bit of new. And so if we're looking to the RPS to guide us around how to deal with that kind of new infrastructure, is that where we should go? Like, move past the NPSIB and just head there to understand what might be, why we might want to think about those two activities a bit differently.
Yes, so yes, first question is are the other provisions of the NPSIB that have not been disapplied by the 2024 Amendment Act still in play? Depending what the answer to that is. If the answer is no, then you fall back on the regional policy statement and any rules in the plan. Yes, I think that's got to be right. Just one point of clarification in relation to the evidence today has just talked about tracks and fences, but remember that Eco R2 1, which one is it? Is it J?
J and K.
Yeah, J includes any other activity essential for existing farming operations. So it's not just new fences or tracks, it's any other, and that's been sort of lost. It's wider than just the tracks and the fences. And whilst that's just in areas A and B, that raises the question that Doc has brought to you about, well, what's the justification for A and B if we don't have a clear significance assessment? And what we do know is they are all significant. They meet the significance criteria. So what's the justification for the distinction? Just a minor point, but in relation to your bigger point, yes, that would be a way to approach it.
Can I just raise another point? It's really about the status of SNAs and whether the plan already includes them. Because I deal with this in paragraph 50 of my 42A report, where basically at notification the definition of SNA included sites that meet the requirements or the criteria in Appendix 4. So we hadn't mapped them, but they were included in the plan by description. So in my mind there's an outstanding question about whether those SNAs were already included in the plan.
And a fine question.
And I've got some questions exactly on that for you tomorrow.
And that would relate to the Amendment Act and the state of the plan at the time that the Amendment Act came in. And then in relation to that dialogue that we just had, specified infrastructure might then come back into play. If it did, it's not contemplating these activities in the exemptions. So this is really core stuff that we have to nail
And
to understand what is available to us and what is not available to us. Yep.
So, Matt, given we're near the end of the day, hold any other things till tomorrow, please, so that we can wrap up with Doc. Yeah.
So I don't think there was anything else more general, but just in relation to that point, so, and I don't have the dates available to me, but the date of notification of the plan is going to be critical then. Because if it's pre-August 2023, it's going to be very critical then. We'll answer that question.
But does all of this, because this is so critical to what is available to us and not available to us in terms of the provisions that we ultimately land on, is this another reason why it could be worth having a bit of planning caucusing? And I'm seeing a nod, because really these are quite thorny matters, and it would be really helpful, I would have thought, to find where everybody's agreeing in what little split hairs there might be left for us.
I was just going to say perhaps legal caucusing as well.
Yes, I couldn't agree more. So we've got the combo going on.
Yeah, I think what we as a panel need to do is actually work out what the questions are that we need, and we have been quite general in saying to the parties in the past that you need to sort out which expert advice you need to answer these questions. I don't see it directing either the planners or the ecologists. It's whatever skill set is required. So when I look at the notification of the MPS IB, it was the 7th of July 23. And the district plan came out on what, 31st of August 23?
It was gazetted, wasn't it, on the 7th of July, and then it didn't come into
Yes, in the Gazette.
or
Yes.
till a month later? But I might have got that wrong.
This, yeah, the intro. date.
Operative date or the commencement date, yeah.
That's the
Yes.
critical.
It was approved by the Governor-General on 31st of May and published in the Gazette on the 7th of July. It does not say in the authority part. So that's something that we'd like the answer for in the morning on that simple question. The more complex one is what next?
And we'll fall out of that initial question.
Yes, yes. Well, yeah. Okay, so is there anything else from Doc you'd like to cover? It's been
I'd just like to talk to you a wee bit about the impact of grazing on Indigenous vegetation. And the reason for raising this is in some of the supplementary evidence, and a particular paragraph in Mr. Wells' evidence. He says, paragraph 25, I consider it as very likely that podocarps will establish in these areas even in the ongoing presence of stock grazing. I'd just like to tease that apart a bit for the panel to sort of think about all the attributes that's there. The difference between cattle grazing and sheep grazing in terms of mechanical or biological effects is quite significant. So it's unfair to sort of just say it's stock. If you're talking about the effects of the stuff, then clarity around what sort of grazing is in or out is an important starting point. And then, the ability of plants to establish. So we're talking about plants that seed and they're this high and then they're that high and then they're, in the case of this one, a podocarp, so they're 20 metres high. But I just think that not all stages of a tree's life are equal in terms of susceptibility to adverse effects, such as grazing. And that whilst a grove of established podocarps or other mature indigenous trees like broadleaf or kamhi could withstand as individuals ongoing grazing, the ability to regenerate or as individual trees to establish in the presence of grazing is quite a different question. And I don't agree that podocarps, in this case, which are slow growing and need particular types of soil, have a chance in the presence of even light cattle grazing. And it could well be different in the case of sheep, but cows are heavy, they have mechanical effects, they can pug the soil, they turn over the soil, because of the amount of fecal material they present, they can create local toxic conditions. So just would like the panel to be aware that that paragraph appears to offer a pathway through for certain types of land use and the ecological effects. I just don't agree, and I think it needs to be unpicked. And if rules or policy about this in terms of Eco R2 are going to be developed, then specificity around this sort of issue needs to be a lot clearer. So that was more about just describing that. And I guess also that the vegetation that I observe in the Hokonui Hills and in other equal parts is because of the topography. It's been a hill country. It's not like it's a flat alluvial plain covered in kakatea, southwestland. It's variable. It has different aspects. The fertility of any given site is different depending on soil depth, things like that. So I think it's the indigenous vegetation pre-human in the Hokonui Hills, I think would have been much more of a matrix of different types of habitats, different associations and communities. So the thought that the Hokonui Hills is always a tall forest area across the board, I think needs to be questioned. In terms of development of policy and effects, you're trying to manage for a multiplicity of sort of outcomes in terms of the plants that are there, the communities that are there. And so again, not assuming that all pathways lead to a large, tall tree forest is my point, and that it's much more interesting, from an ecologist's point of view, it's much more interesting than that, because it's a range of shrub communities. You've got drylander communities like Kowhai Forest, or you've got edge communities with Muehlenbeckia vines. We've seen through the oleary tree daisies, you've got an open matrix of low, mid, not canopy, not traditional canopy trees, but canopy trees in an edge forest or a dryland forest. So I just wanted, before we finish, to sort of make the panel aware that some of these statements need to be unpacked when you're trying to describe the effects you're dealing with and the directions or the outcomes you're seeking in terms of the values that are present. That's all.
Thank you for that. I actually interpreted the statement that was in the paragraph when he's referring to stock, given that there's no cattle on the Okanois, it was only sheep.
Yes, and we did hear this morning about pigs and deer.
Yeah,
So-
there was beef. Yeah, okay. Yeah, all right. Thank you. Right.
Thank you.
Then sorry, that's a nice segue to, and I know it's 20 to 6 and you don't want to segue, but there was one thing around the FX management hierarchy that I think was being thrown in your direction, and the quantification of, is this an offset or not an offset in terms of the nibbles and the regenerating areas, whether they are an offset for the nibbles. So that idea of quantification, I guess, is what it throws up for me, and the effects management hierarchy. So just inviting you to pick that up, and I think it probably relates to what you were just saying around the matrix and the different habitats and things.
So you've got avoid, remedy, mitigate, and then offset. So if you can't avoid, you're expected to, if you can't remedy, you're expected to avoid, mitigate. But by that stage, you're actually agreeing you're going to have loss. So when you enter offsetting, by definition, there's loss going on. You're figuring out a creative way to replace that. So when it comes to rare species or rare and threatened ecosystems, and you're talking about offsetting, you're agreeing that will be loss of a limited resource.
If I could just add, I know it's time to go home, but just in relation to offsetting, this is where the Supreme Court's recent decision in East West Link is really critical, because they made absolutely clear that offsetting means like for like. You cannot offset the loss of significant indigenous vegetation. You certainly cannot offset the loss of threatened and at-risk species with other indigenous biomass.
Yeah, that was my understanding.
Yeah.
That's what I was expecting you to tell us.
Yeah.
But it does relate to, what is being lost and what is being gained, and the nature of the outcome at the end of it all.
That's right. And there's also helpful definitions. There's two sets of definitions in the MPSIB. There's the definitions at the beginning. There's also definitions relating to specifically to the offset appendix that you'll find helpful when you're thinking about that question.
That will depend on answers to our original
Critical
question. But the reason for asking that effects management hierarchy question is that you also pointed out it was best practice before the MPSIB came along. So, kia ora.
All right. So I think that's drawn us to an end of proceedings for today. To the team from DOC, we've really appreciated having you here. Good career in terms of some of the discussion backwards and forwards and some of the issues, and it'll continue tomorrow. So, if you've got nothing else to do tomorrow, please tune in. Or have it tuned in the background while you are doing your other things. There may be some things that jump out of that tick some boxes for you, or likewise. And to the rest of the submitters and team that are here, thank you for your input today. It's been a long day. We started 9 hours ago. Tomorrow could be an equally demanding day. So I'll close proceedings for today, and we'll adjourn till tomorrow morning. To the panel, thank you for keeping up with everything. Cheers.